A Florida teenager allegedly used violence, threats, and coercion to force girls to engage in sex acts with him. And Orange County deputies worry there could be even more victims out there. We are digging deeper into investigators' conclusions that the high schooler's behavior was, quote, emotionally and physically brutal. And what happens next? We're going to talk about it all with a criminal defense attorney. Welcome to Sidebar, presented by Law&Crime. I'm Jesse Weber. All right, not to take away from the seriousness of this topic in any way, we're going to jump right back into it. But look, it is the holiday season. You might be thinking about what to get somebody. We have a great sponsor that I want to quickly tell you about. It's the perfect deal for the perfect gift. It is the Chef IQ Sense Smart Meat Thermometer, okay? This is the secret to stress-free, flawless cooking. So whether you're a seasoned chef or you're just starting out, this smart thermometer, it guarantees perfect results every time. There's no more guessing. There's no more overcooking. You just insert it. You select your food, your cooking method, your preferred doneness. You relax. Your app's going to alert you when it's time to flip, remove, rest. It is perfect food every time, from holiday turkey to prime rib, wings, brisket, salmon. It works for the oven, the grill, the smoker, the air fryer. You really can't mess this up. It is the gift that makes cooking stress-free and fun. And with my code SIDEBAR, you can save 30% off site-wide at chefiq.com. An Orlando 18-year-old is now locked up in jail with no bond after his arrest for allegedly raping, choking, slapping, and spitting on a teenage girl. Oh, and by the way, he's also accused of recording all this. This is a guy who's accused of maybe attacking multiple girls. According to investigators, this behavior dates back to 2020, when Rafael O'Reilly Lerner would have been in his early teens. And deputies say their sights were set on this guy after someone notified a school resource officer that a student, according to prosecutors, was being victimized. And as they started digging into the accusations against the teen, they realized there are potentially more victims out there, possibly too scared to come forward. But that could all change now that O'Reilly Lerner is in an Orange County jail cell. Now, we've requested copies of the arrest affidavits from Orange County courts. So far, we haven't heard back from court officials, but local Florida outlets are reporting the very disturbing details from documents that they've seen, so let's talk about it. Something that online court records do show is that O'Reilly Lerner is facing 13 charges, 9 felonies, 4 misdemeanors. 4 counts of sexual battery of a victim under the age of 18, 4 counts of battery by strangulation, 1 count of false imprisonment, and 4 counts of misdemeanor battery. According to an arrest affidavit and pretrial detention motion that were reviewed by multiple outlets like Fox 35 Orlando and News 6 and the Orange Observer, O'Reilly Lerner allegedly assaulted a 17-year-old girl multiple times, including at his Orlando home and in his car. You have neighbor Ruben Ramos, who told Fox 35 Orlando that he saw O'Reilly Lerner get arrested outside of his house. Said about an hour later, investigators towed his car away. Okay, so to talk about the specifics of this case, what's next for the suspect, I want to welcome back on criminal defense attorney Joe Tamburino. Joe, thank you for taking the time. What stands out to you about the charges that O'Reilly Lerner faces, other than the fact that there are multiple charges and he's so young? What should we know about these charges?
Well, that they're very serious. I mean, under Florida law, and I'm not licensed in Florida, but under the Florida statutes, for some of these charges with the sexual battery, you could get up to life in prison. So they're very serious charges. And also, and this isn't surprising, unfortunately, in today's world, which is the threat of releasing a sexual or sexually graphic material of other individuals. I mean, we hear this all the time. Like in Minnesota, we have a revenge porn statute, which means that if, you were in a relationship with someone and they have, naked pictures of you, if you release those without their permission, then you're going to be committing a crime.
Yeah, and I want to get into that about the potential evidence they have against him. When you look at these charges and the amount of charges, is it also an advantage for the prosecutors to move forward with as much as they possibly have, to use that as leverage to maybe work out a plea deal? Because, I mean, having to take this to trial and having this alleged victim testify, I always wonder if they can, assert the most serious charges they can as a way to maybe one day negotiate a plea deal where he pleads guilty to lesser charges or some of the charges and avoid trial.
Yes, I think you're right. Most cases do end with some type of plea bargain. They all do, whether it's state, federal, no matter what state you pick. Most cases are pled out pursuant to some type of an agreement, especially in these kind of cases. Because when you have all this kind of mountain of evidence, meaning that you not only have the victim's information, but you have electronic evidence showing that, why, yes, there are these images of the victim or victims, that's a mountain of evidence. And many times you're going to have some type of deal worked out. But in this case, I don't see a deal being worked out that does not include some hefty amount of prison time.
I want to go through this a little bit more. So you have outlet WOFL, who is citing the Orange County deputies, reported that O'Reilly Lerner is accused of multiple sexual battery incidents between October 29th and November 13th. School officials were apparently notified that O'Reilly Lerner and this 17-year-old alleged victim had gotten into an argument before he asked for sex. She apparently says no, which reportedly led him to grab her by the neck, the back of the head, threatened her. This is all according to the sheriff's office, their allegations. Now, Lerner also allegedly threatened, and this is what we talked about before, to leak compromising photos and videos of this girl to her parents and the public in general if she didn't engage in sex acts with him. And some of those threats were apparently sent over text messages. So, Joe, digital evidence trail? I mean, if they have that, I don't know how a defense attorney gets past that.
You're absolutely right. And in today's world, this happens so often where there is a digital evidence trail. And unless you have some type of proof, being from the defense side, let's say, that someone else did this, they got control of your device, somehow they knew of your passwords and they did this, so they set you up. Unless you have some evidence of that, it's very solid stuff coming against the defendant. No matter how much we all know that digital evidence lasts forever, defendants out there continue to do this. They continue to text, email, basically giving the whole case to the prosecutor.
I didn't even mention this. There's a disturbing twist. This 17-year-old believes that O'Reilly Lerner recorded himself allegedly calling her degrading names and hitting her and choking her and raping her. So there's text messages are one thing, Joe. That's true. There's videos of this. I mean, what does someone say? This is different than like an adult case. I mean, 18 years old, but a different kind of case where somebody says, oh, well, it's consensual adults who are involved in some sort of power dynamic and role playing. That's not what you're going to have here. If these allegations are true and this is what we're seeing, again, videos, I don't know what you do.
That's correct. With the videos, it's going to be very damaging. But again, not surprising. I've been doing this for 37 years now. I couldn't tell you how many thousands and thousands of cases I've worked on, over 100 and something jury trials, state, federal, and it never amazes me how many times people will record at least part of their crimes, especially when it gets into the sexual arena. I've seen cases like this all the time where the perpetrator, the alleged perpetrator, will actually have a recording of something dealing with their crime. And when that's found, whether it's given up by, some witness or pursuant to the execution of a search warrant, it's highly damaging to the defendant.
If these allegations are true, someone this young, it's so different.
Oh, absolutely. It's so different. Yes. And that's why the law is going to have a greater penalty. And when you have all these repetitive acts, what you're also going to run into from the defense side is a consecutive type of sentencing. And here's what that means. When you have a number of different acts, but they run concurrently in sentencing, that means regardless of how many convictions you get, they all run at the same time. So if you got 5 years on one charge and 5 years on the other, with a concurrent sentence, you're going to serve 5 years. However, when you have these types of cases with which completely different acts on different dates, you could get consecutive sentences, which means they stack, they add up, and they're going to add up fast.
That's a really good point. That's why you see the multiple charges there for different separate incidents. At least that's what it appears to be. Now, I will tell you this. WOFL discovered, apparently, this isn't O'Reilly Lerner's first run-in with the law. No, according to records that they reviewed, you had a 19-year-old woman accused him of sexual battery and voyeurism back in August 2023. A 16-year-old said that O'Reilly Lerner threatened to hurt her if she didn't send him nude images. And this is shocking, according to WOFL. Investigators say O'Reilly Lerner was also arrested in connection with some sort of domestic battery incident in 2020. 20. So he would have been what, just 12 or 13 years old at the time? Now, Joe, from a reporting point of view, from a narrative point of view, disturbing, shocking to say the least. From a point of law view, can all of that potentially come in at a trial?
Yes, it's called other act evidence. Let me give you an example. Method of operation, someone's MO. If someone is accused of raping another person by the use of, say, certain types of materials, say they use a red rope all the time, they use a yellow bandana to cover the eyes, they do certain things, and they have a history of doing that or other acts of doing that, you could use that to say, look, those other acts are relevant here because this is the guy's method of operation. It goes to his intent, his planning. So what they could do here in this case is say, look, with this guy's other acts, they're relevant here because he does the same thing. He gets a victim who's younger, he sexually abuses them, he threatens them with something, and he physically abuses them. So you could try to get all of those in, and even if the judge only lets some of it in, it's still going to be very damaging.
Well, if you have records that are related to alleged crimes when, let's say, he was a minor, aren't those sealed? They can still come in?
No, not all the time. Yes,
Okay.
Some cases are sealed as a juvenile, but it depends on state law. There are situations where you could use something from a juvenile's record. It's not always completely sealed.
Let me ask you this. So O'Reilly Lerner appeared in court last week. The judge denied him bond, forbade him from contacting any of the alleged victims or witnesses. I guess that means from behind bars, right? Trying to use the phone system there. Possessing any sort of weapon and also being online. Take a listen.
I don't want him on the internet or being able to photograph or send images to the alleged victims.
Joe, those were interesting conditions, particularly keeping him behind bars. You think that's the right decision?
Yes, you have to keep someone like this behind bars or a high bail because they have a history. It seems like the weight of the evidence, at least in terms of making a bail decision, is quite great against him. Of course, he still has the presumption of innocence. Of course, he has the right to a complete defense, including an attorney if he can't afford one. But when you're a judge, what you have to do is balance out public safety with this person's right to a bail. So many times in a case like this, depending upon state law, there will be quite a high bail or no bail at all.
Yeah, the statement from the Orange County Sheriff's Office, it really hammers home their fears about O'Reilly Lerner's allegedly predatory behavior because it says he ingratiates himself to young women, coerces them into sex, becomes extremely violent, and videotapes and photographs his victims during sex. Then he threatens them with exposing those videos and photos publicly and to their parents. Our detectives believe he's a predator and that this behavior has been going on for some time and has escalated over time. We're asking anyone who has any kind of concerning interactions with O'Reilly Lerner to come forward, and anybody with information is being asked to call the Orange County Sheriff's Office non-emergency line. The number there on the screen, we're going to put it up there as well. It's 407-863-HELP. Joe, do you believe more people would come forward? And to be clear, I'm sure, like we've seen before, a defense attorney will say, well, the floodgates are open, everybody's going to make accusations. We see that more in celebrity cases. But do you think that this is going to be a situation where more people may come forward and you might see additional charges?
I wouldn't be surprised if more people came forward because, let's face it, somebody just doesn't wake up one morning and say, I'm going to rape someone, I'm going to sexually abuse someone. Usually they have some type of history. What might that history be? Maybe lesser types of sexual assault, or maybe what's called grooming. When you mentioned that the Sheriff's Department talked about how he supposedly would ingratiate himself with these young girls, that's all part of what's called grooming evidence. Meaning that you're trying to get your victim to think what you're doing and what you will do to them in the future is okay. You're trying to get them on your side, that what you're going to do to them is normal. You see this in many, many child sex abuse cases. So all of that is relevant here. And when you start executing search warrants, going through a defendant's email, their computers, iPads, phones, whatever they have, zip drives, whatever they have, you might find other evidence. So I would not be surprised if other cases arose from these charges.
And to be clear, when somebody would call in, police not only would listen to the account, but they have to corroborate it, right?
Absolutely, they have to corroborate it. Sure. When someone calls in on a tip or saying, look, this person did this to me too, then a whole new investigation starts. Of course, that individual will be debriefed. They'll get a statement from them, and then they will try to corroborate what they're saying. What is corroboration? Going through texts, emails, instant messaging, whatever it is, seeing if other parties, third parties, saw these individuals together, seeing if there's any physical evidence. Maybe another person says, he was at my house and in my bedroom, and I still have the blanket or the pillow or whatever it was that he touched. So you could try to get DNA evidence from that. So a whole new investigation starts when you get a new accusation.
So, I'm listening to this, and it's eerily reminiscent of another case that we've been actively covering here on Sidebar. It's made the headlines as well. It's the case of Oklahoma teen Jesse Butler. And I just want your take on this. So you have this essentially a high school predator, by all appearances. Many would say he seems to have gotten away with his crimes. He was arrested after two of his ex-girlfriends, LS and KS, that's how they were identified, reported to police that he allegedly sexually assaulted them throughout the relationships, even apparently going so far as to film himself strangling one of the victims until she lost consciousness. Both girls reported him to the school in September of 2024. One got an emergency protective order, but the claim was that he kept violating it. There were arrest warrants that were issued in January and February of this year. For some reason, they weren't apparently executed for weeks, but he was finally arrested at his home in Stillwater, Oklahoma on March 4th.
Okay. All right, let me know. Thank you. Hello?
Hello. Are you Jackie?
Yes, I am.
Hi, Jackie. I'm Detective Bruce with the Stillwater Police Department. We're here because we have a warrant for Jesse's arrest. I assume you know that already. Okay. Is he here?
Yes.
Okay.
I told him not to answer the door till I got home. He's scared to death,
So here's what's going to happen. We're going to take him into custody. His bond is $25,000.
Okay.
Once he gets to the jail and we get him booked in, well, I guess on the way to the jail, I guess you could contact a bondsman.
Yeah.
Or if you have 25 grand lying around, you can do that. But if you contact a bondsman, then they can post his bond and he can get right out today.
Okay.
So,
what kind of time frame does that look like? Just out of curiosity, like midnight tonight or
no,
an hour?
You can contact a bondsman and it'll be an hour and a half or something.
Candy Baker, I'm sure y'all know.
Yeah.
Candy.
So
she's the one that told me.
It's a pretty quick process.
Okay.
We just have to get him booked in.
Okay.
And then once he's booked in, and just so you know, he is a juvenile, so he won't be with any adults. He can't be housed with any adults.
Okay.
So there is a chance that he may be moved over to Payne County, but for right now, depending on how long it takes you to get with her and get bond
I'll
set
call
up,
her right back. So
then he'll probably just be at our facility at the city of Stillwater.
Okay.
And she can
Whose
come over
call
there.
is that?
It just we can only hold him for 6 hours.
Oh, okay. So if I get it done now, we're good.
Yeah.
He's not going to be moved.
No.
Okay, perfect. Okay.
Yeah, he shouldn't be. The only big holdup is if we have somebody else in the jail because we can't have them intermingle. If they're booking somebody in, it could hold us up 15, 20 minutes, something like that. But it's not going to be a long thing generally.
Well, we're ready to obviously tell our story too.
Yeah.
Jess, it's Mom. Open the door. Give me your wallet and phone and stuff. So, your what? They're in the car. Well, okay, it's fine. It's not locked or anything, is it? Okay. So, can you tell him what you just told me, or?
Yeah. So we're here. We're obviously going to place you under arrest. There's a warrant for your arrest. We're going to take you to the jail. I told your mom that she can contact a bondsman, and you shouldn't be very long. But there just is a process for paperwork and stuff. But right now, you do have to come with us, and I do have to put you in handcuffs. So turn around for me. I
You know we're going to win this. It's okay.
Yeah.
I'll get you out. For me? All right. Stay silent. Rick knows about this. Candy's on this, Dad's on his way. We're coming to get you, okay? Stay strong, okay? Say your prayers.
Okay, so he's going to go right to the city of Stillwater jail, and if you'll just contact her, then she does this all the time. She knows what to do.
Yeah.
Make sure
Okay.
she knows Stillwater Police Department, not a county.
Stillwater Police Department on Lewis.
Yeah.
Yeah.
Let them know that we're the ones that pick him up.
And when you say we are
Stillwater PD.
Stillwater PD.
Yeah.
Okay.
That way they don't think he went like straight over and over to the county.
Awful experience for a child.
Pat you down. Spread your feet for me. Nothing in your socks.
Good, Jess. Do that.
And this is where it took a radical change. So Butler entered a no contest plea to a long list of sexual crimes, rape, attempted rape, strangulation. And in this plea, right, a defendant doesn't admit their guilt necessarily. They also don't dispute the allegations, but they're pleading no contest. They're convicted. And the now 18-year-old Butler, he was facing more than 75 years behind bars potentially, but in this reversal, the court granted Butler a youthful offender status, meaning instead of prison, he was given probation, conditions that require him to do things like complete therapy. And according to the victim's parents, Butler seemed like a perfect high school boyfriend, and they were shocked when their daughters revealed what was allegedly happening behind closed doors. And we're trying to make sense of it. And we actually had a chance to speak with the attorney who is representing KS, so Rachel Bussett. Spoke to her on Monday. She is arguing that her client's rights under Marcy's law were violated. Essentially that she wasn't properly consulted or heard before that controversial plea was struck and didn't know what was going on until the last minute.
So Marcy's Law is a crime victims' bill of rights, and it was passed into the Oklahoma Constitution in 2018, supplemented by statutory definitions and processes that are supposed to be given to victims. Along the way, if you read through the statement of facts and procedural history in the case, you'll see that there were a number of times where my clients weren't given proper notice. They didn't follow simple procedural aspects of what we're supposed to do as lawyers. There were other times where they were given partial information or no information at all, or the information that they were given was given in such a way that they didn't have a meaningful time to process it, work through it, and understand it. So there are different things that happened at different times.
And is the goal for Jesse Butler to ultimately be resentenced, for the youthful offender status to be stripped away, for him to be sentenced as an adult, for him to get prison time? Is that something, or is it at the very least for your client, her family, to be heard, to just be heard in a courtroom? What is the outcome that you're looking for at this point?
We're looking for an outcome that holds him accountable. And I know there are going to be people that say, well, this does hold him accountable as a youthful offender. But the biggest thing is he hasn't admitted what he's done. For the Youthful Offender Act to work the way that it's supposed to act, there has to be a taking of responsibility. And he hasn't taken any responsibility here. So we need some sort of admission of responsibility at a minimum.
Yeah, so Bussett confirmed that the victims and their families, they were told about the new youthful offender status of the case just before Butler's hearing. Joe, what is your reaction to a case like this? What is your reaction to the sentence that he was given? And when we're talking about, you know, a young man who pled no contest to sexual related crimes, and we're talking about another young man who's accused of sexual related crimes, should they be given the same punishment as an adult? Your thoughts?
Well, it depends on the circumstances. It truly does. I think in this case, the O'Reilly Lerner case, I doubt he's going to get any type of youthful offender status if such exists in Florida. I just don't see this case as falling into that. In terms of the Oklahoma case, yes, I was surprised at that outcome. I was more surprised by the allegation that you just put forth that the prosecutor wasn't properly communicating with the victim and the victim's family. And here's why with that. Every state in the union and the federal government have victim rights laws, like you mentioned, the Marcy laws. And whenever a prosecutor is going to offer some type of plea bargain to the defendant, in most states that I know of, the prosecutor has to let the victim or the victim's family, if they are juveniles, know what's being offered so that they could put in their proper objection. Now, a victim can't quote unquote tube the deal, meaning that they could go into court and say, do not accept this plea and actually make a specific motion for that, but they could let their voice be heard. They could say to the judge, they could say, look, we're against this plea. We've told the prosecutor that. So they have a right to be given their day in court. So I was surprised at that allegation that the prosecutor supposedly did not communicate with the alleged victim in the case. What I would want to know, and I don't know Oklahoma law, is whether or not the prosecutor, because of the sentence that was given, is going to do any type of an appeal of the sentence. You see, if a prosecutor offers a deal to someone and the judge follows that deal, well, then the prosecutor's not going to appeal. But if someone simply walks in, pleads no contest, and the judge on their own decides to do something, the prosecutor in many situations does have a right to an appeal. So we'd have to get into the very finer points of that.
No, it's interesting. I will tell you the DA's office there is refuting the allegations that are being alleged against them about their role in all this and not keeping the victims aware of it. So there is a back and forth. If anybody wants to follow that, I did a sidebar on it again Monday. But Joe, thank you so much for taking the time. Really, really appreciate it. I know this is a really disturbing case, but always appreciate your expertise. Thank you.
Thank you.
And that's all we have for you right now here on Sidebar, everybody. Thank you so much for joining us. And as always, please subscribe on YouTube, Apple Podcasts, Spotify, wherever you should get your podcasts. You can follow me on X or Instagram. I'm Jesse Weber. I'll speak to you next time.